All right. So this is Lunch with a Lawyer on, we're going to talk about bankruptcy discharge of student loans. This was aired on January 16th, 2023. So if you're watching the recording after the fact, this is the lay of the land and the facts as they exist as of today. Things are always changing on the student loan landscape, but this is where we are right now. So there's been a lot of talk about what President Biden and the Department of Education have done with federal student loans in bankruptcy. So I wanted to talk about what it is and what it isn't, so everybody's clear on what these guidelines are, and really have a fairly good idea of whether you would qualify for a discharge of your federal student loans should you file bankruptcy. So that's what we're going to talk about today. Now, on November 17th of last year, Biden administration Department of Education released guidelines for how requests for discharge of federal student loans are to be handled in bankruptcy court by their attorneys, the U.S. attorneys that are assigned to the case. And this is a very good sign. I think that President Biden and his Department of Education have done what they can outside changes in the bankruptcy code by Congress to help folks with student loans. So there's some good news, but there are some things to bear in mind. Now, because there's always a catch, all right? First of all, you still have to file an adversary proceeding seeking discharge. Now, what does that mean? Well, it means that student loans are non-dischargeable by default. So if you were to just file a bankruptcy, list all of your debt, when you get to discharge, your credit card debt will be gone, your medical debt will be gone, personal loans will be gone, that sort of thing. But your student loans will still be your personal responsibility. That will not be discharged. Discharging them requires an additional affirmative step after you file the bankruptcy petition. It's called an adversary proceeding, and that's a fancy term for a bankruptcy lawsuit. All right, so you file a lawsuit, it's in federal court in bankruptcy, suing the Department of Education and saying, hey, I believe that I meet the requirements to have my federal student loans discharged. And then depending upon the outcome of that lawsuit, whether a judge rules that it's dischargeable or you settle the case with the Department of Education, it will determine whether or not those student loans are discharged. Now, the guidelines only apply to federal student loans. I get questions all the time about, well, what about private loans? What about New Jersey class loans through HESA? Doesn't apply. All right, just federal student loans. The guidelines don't change bankruptcy law. All right, what these guidelines are a set of instructions to the U.S. attorneys representing the Department of Education as to when to settle these discharge claims. And they only apply to bankruptcies filed after November 17, 2022, or filed before then, but are still open. So this is a prospective set of guidelines for new bankruptcies. Unfortunately, at least right now, and again, the landscape changes, but it is not retroactive. You can't go back and file reopen a bankruptcy that you filed several years ago in order to discharge under these guidelines. Now, you can still go back to an old bankruptcy, you can still reopen it, and you can still try and get them discharged with an adversary proceeding, but you can't use these guidelines. And you still have to prove undue hardship under what's called the Brunner test. So the procedure, adversary proceeding, hasn't changed, and your burden of proof, what you have to prove, hasn't changed. It's just been easier, and I'll get into that. So what is the Brunner test? Well, under the bankruptcy code as it currently is, in order to discharge a student loan, you would have to show that paying back the loan would result in an undue hardship. Right now, the determination of an undue hardship is done through a three-part test. You would not be able to maintain a minimal standard of living if you were forced to make payments. This financial situation is a persistent state of affairs. In other words, it's likely to continue into the foreseeable future, and you have made a good faith attempt to repay the loans. All right, here's the thing. It's very subjective, as you can imagine, when I went over those the three-part test, those three prongs. They're always subjective, and they can vary from court to court and case to case. Throughout the country, there are judicial decisions and published opinions that vary on who passes the test and who doesn't. So what constitutes a minimal standard of living? What is it? How do you determine that? How do you know, really even going in, to say, look, if I bring this adversary proceeding, what's the likelihood I'm going to win? You know, do I have a case? And this question I'm asked all the time. What's a minimal standard of living? So what makes a persistent state of affairs? Again, what does that mean? Does it mean you've tried for, it's been in repayment for 1 year, 3 years, 5 years, 10 years, 20 years? How long has this been going on? What constitutes a persistent state of affairs? And finally, what's a good faith attempt to repay? What does that mean? So very subjective. And what the guidelines do is bring objectivity to the very subjective prongs of the test. And it gives the U.S. attorneys specific examples of what each of these means and must apply them in settling adversary proceedings for discharge. Now, bear in mind, again, this doesn't change the bankruptcy code. So just because you meet, let's say we get to the end of the presentation, you say, hey, I pass, all right? A judge doesn't have to go by these guidelines because the code hasn't changed. The case law hasn't changed. He's going to make his own, he or she is going to make his or her own independent decision on whether you pass the test. What this does is it tells the U.S. attorneys, if you pass, settle the case, resolve it. Say, you know what? You do pass. Let's settle this. We'll submit an order to the judge that discharges your loans, and that's the end of it. Okay, so it doesn't change the law, but it does enable you to engage in meaningful discussion with the U.S. attorney on whether you pass the test. So, first prong, what is a minimal standard of living? What kind of income? What kind of expenses? Can you have any money left over? In the past, minimal standard of living meant you lived in a loft or something, you know, with no. It's a certainty of hopelessness, I believe, was the magic words. Well, first they look at your income, and they take all of your gross income and lump it together and total it up. Now, this is not your take home. This is your gross income. So from your job, it can be from Social Security, pensions, VA benefits, unemployment benefits, all of your income. All right. So then they take that total and then they compare it to the median income for your state for your family size. Okay. So these come from the IRS. So the IRS have standards. If you're saying, I can't afford to pay my taxes, well, what kind of income do you have? What kind of expenses? They had this test to help negotiate a payment plan or an offer in compromise. So these vary from state to state, and they're adjusted every 2 or 3 years. And so for one person, 2 people, 3, as you can see, and then for each person over 4, each additional person is another $9,900. So you can take a look at you can look at yourself, right? You can see, hey, what's my gross income and does it exceed, and what's my family size and does it exceed these gross numbers? Now, if you have an over the median income, that could cause a problem for discharge. You'd have a much tougher time convincing the U.S. attorney to agree that it's dischargeable. And as student loan attorneys, our thinking is this is a new program. It's just started. You're probably best not to push your luck and try and test it with an over the median income debtor. So that's income. What about expenses? Well, your individual expenses are not used. The IRS standards for expenses adjusted for household size, again, are presumed. Okay, so just like we have objective income standards, we have objective, to an extent, expense standards. This means that if your actual expenses are less than the standards are used, and you benefit, right? But if your actual expenses are more, such as a car or a mortgage payment, then they're capped at the standards and you lose. However, you can include other necessary expenses as well as reasonable expenses not yet incurred. What does that mean? Well, a lot of times, and I've had clients, a married couple living with the in-laws because they can't afford rent because they have all this debt, or a single person living in the parents' basement, and they are trying to get rid of this debt so they can afford to move out and pay rent and pay utilities and stand on their own 2 feet. So that's ultimately going to happen. So it's a reasonable expense not yet incurred. I'm moving out of my parents' basement. I'm moving out of my in-laws' house. Now let's get some standard expense examples. Now here, and again, this is for Gloucester County because it actually varies from county to county and area in New Jersey, and my office is in Gloucester County. So this is housing expense, which you can see what that includes, all totaled together for 1, 2, 3, and 4 people. Now, I will provide that. I have this link down below there on all the different housing and utilities expenses throughout the state. I will send out an email to all of you with that link. So I know it's a long one, and rather than trying to jot it down, and I'll also try and send you links for sort of all of the expense standards that the IRS uses so you can have a better idea. I just obviously can't go over all of it in detail in this presentation. So do you pass? Well, it's simple. It's arithmetic. That's what's beautiful about this. It's objective. It's not subjective. So if your expenses are greater than your income, then you pass the first part, right? Simple arithmetic. Now, if there's an amount remaining and it is less than your standard payment on your loan, so if you have $200 left over and your standard payment is $1,500, well, then you pass again, because you wouldn't be able to maintain that minimal standard of living if you were forced to repay the regular payment. If your expenses exceed the standard amounts set for the IRS, you're going to have a tougher time convincing the attorney for the Department of Education that you pass this part. So just like if you have above the median income, if you have a lot of other expenses that don't really fit within the guidelines, it becomes less objective and becomes a more difficult discussion. So that is the first part, whether you can maintain a minimal standard of living. But what constitutes a persistent state of affairs? Well, here we create what are called rebuttable presumptions. And there's a whole list of them that if any of these apply, it's presumed to be the case. Okay. It's true. And unless the U.S. attorney has some evidence that he or she can use to rebut it, to say, no, that's not the case, and fight you on it, then you've established it. So what are these rebuttable presumptions? You're age 65 or older. If you're heading into retirement, your financial situation has pretty much been established long-term. You have a disability or chronic injury impacting your income potential. So again, you're never going to earn more than you could or have been. You've been unemployed for at least 5 of the last 10 years. You failed to obtain the degree for which the loan was procured. So if you, for example, dropped out of medical school or law school or never completed your MBA, that can be used. The loan has been in payment status other than in school for at least 10 years. Now, you should claim all the presumptions that apply, if not only one. And if none of the presumptions above apply, you can still attest to other facts that are relevant to the future inability to pay. Okay, so it's not an exclusive list, but it gives you an idea of what they're looking at and what they're going to consider. Now, as far as a rebuttable presumption is concerned, the U.S. attorneys have been instructed, look, don't be overly aggressive, okay? Don't be an a-hole about it, all right? Rebutting these presumptions should be uncommon, not routine, not SOP, uncommon, and must be based on concrete factual circumstances. So if you're going to try and rebut a presumption, you better have some facts and evidence to back it up. Now, finally, good faith effort to repay. Now, again, we're using rebuttable presumptions here. as to whether you made a good faith effort to repay. So let's take a look at those. You made a payment. Now, obviously, the more payments you made, the better, but making at least one payment gets you started down the road. You applied for a deferment or a forbearance other than in-school or grace period deferment. So you didn't ignore it and let it go into default. You really tried to do something to keep from going into default and address the loans. You applied for an income-driven repayment plan. So you couldn't afford to make the regular payment, but you tried to get something income-driven to make it more affordable. So you really tried to make the payment. You applied for a federal consolidation loan. Again, made efforts to deal with the situation. Responded to outreach from a servicer or collector of the loan. And this is a little broader, but engaging meaningfully with the Department of Education on their loan servicer or their loan servicer regarding payment options, forbearance and deferment options, or loan consolidation. So you reached out, you talked to them, you said, look, I know I've got this obligation, I know I've got these student loans, I'm really struggling, what can I do? Okay, you just didn't ignore it. Or you engaged meaningfully with a third party that they would believe would assist them in managing their student loan debt. You hired me, okay, or a student loan attorney, and you really tried to work it out outside of bankruptcy with non-bankruptcy solutions. Efforts to obtain employment, and you made efforts to obtain employment, maximize income, and minimize expenses. So you really did try and cut your budget down to the bone, worked a second job, or tried to get a better job or a raise, whatever it is, to try and generate the disposable income necessary to afford the monthly payment. Your actual payment history, evidence that you lacked financial means to pay, should be considered. And again, enrollment in an income-driven repayment plan. And this is an important guideline because in the past, what would happen is you would file this adversary proceeding, say, I can't afford to make the payment. Then the Department of Education would come back and say, well, no, wait a minute. In an income-driven repayment plan, because you make so little money, your payment would be zero. Are you saying you can't afford zero? Okay. But practically speaking, is zero really a payment, right? So what they're saying, what they're instructing their U.S. attorneys are is non-enrollment is not controlling. So if you have an explanation, a reasonable explanation or evidence as to why you didn't, then they must accept that. So they can't just say, oh, you didn't go in an income-driven repayment plan. If you had, you wouldn't have this problem. Now, the attorneys should not impose their own values on their debtors on your life choices, okay? Which is, wait a minute, you know, why are you spending this much money on such and such? Why are you, can't you cut that expense or that sort of thing? So you know, that's, again, is subjective. What the attorney might do is different from what you would do, which is what different when somebody else might do. And that you lose the objectivity. So they're not allowed to do that. Now, if you game the system, okay, and you affirmatively created a situation in order to be able to check the boxes, then that's a lack of interest in repaying the debt, and that's evidence that would rebut a presumption. So it really has to be, a good faith, honest attempt. So those are the three prongs and how they become objective. And you can see how you can really look at these and see, do I pass the test or not? But whether you pass the test or not, is bankruptcy really the option for you? I'm a bankruptcy attorney, but I'm not going to try and twist your arm into filing bankruptcy if that's not the right solution for you. So what do you look at? Well, here are my recommendations. I would look at bankruptcy as a solution if you have not filed bankruptcy before, and if you did, it was after you took out these loans. So you can't go back, obviously, before November 17th, but as time goes on, if you have a post 11/17/22 bankruptcy, you can go back and reopen it and use the guidelines. you have more than $12,000 to $15,000 in other debt, such as credit cards and medical bills, and these are my numbers, just from my experience, and you only have federal student loans. So in other words, if you kind of file bankruptcy anyway, there are other economic indicators or reasons to file bankruptcy. Hey, look, I've already got this credit card debt that's non-affordable. I've already got these other medical bills. This is that I need to deal with. And my student loan problem is federal student loans, then yeah, it makes sense. Okay. But if you don't have a lot of other debt, if really your student loans are your only problem, then there might be some non-bankruptcy solutions you could look into, or try and work out payment plans with the private student loan lenders if you're in default. And I've helped people with that. So that's kind of my guidelines. And as I said, otherwise you should look into for non-bankruptcy options to deal with them. Now, talk to an attorney if you're in my area, as indicated, and you think bankruptcy, you look at this and say, you know what, I think I pass. And I think that these guidelines or reasons to file bankruptcy and use that as a solution to the student loans makes sense. I'd be happy to talk to you. If not, and you're looking for a non-bankruptcy alternative, and again, I'll email the link to the attendees on what this is a link to an analysis portal I use. You can upload your loan history from the studentaid.gov website, and I can take a look at it. I'll review it for free and then see if there's something that can be done. And if there is, we can set up an analysis appointment to take a look at that. So hopefully that was fairly clear and understandable. But if there are some questions, I'd be happy to answer them about the presentation. Unfortunately, as I'm sure you understand, I can't answer questions specific to your situation. That really involves us sitting down and talking. But if you have something's unclear about any of this, jump in and ask. Either ask or type it in chat. Okay, good. I hope that means it was clear and understandable to everybody. I know this can get a little complicated, but all righty. Well, I'll get an email out to everybody. It may not be this afternoon, but as the participants with the links, and we can go from there and see what happens.